Welcome to Bloomberg Law on Demand. I'm Lee Pacchia. We're taking another look at the NFL lockout today with a special focus on the antitrust lawsuit filed by certain players against NFL owners. Joining me to discuss, we have Matt Cantor. He is an attorney at the law firm Constatine Cannon based here in New York City. Matt, thanks so much for coming in today. Welcome to the program.
Thanks for having me. I appreciate it.
So first question I always have to ask, are we going to actually play football in 2011?
Oh, I believe we are. I believe there's too much money at stake, both from the owner's perspective, the player's perspective, and I should also mention from the television network's perspective, for them to forego an entire NFL season.
It's not too often in life that we see problems emanating out of too much money. It's usually the opposite. I got to ask, are we surprised at what we're seeing?
I don't think we're surprised. I think that both the players and the owners still have time to make a deal. The NFL preseason really doesn't start until the midsummer, end of June, early July. So I think that this is a tactic. I think it's a way for the players to try to get additional bargaining strength, but I'm not sure it's going to be successful.
All right, so let's talk about the specific tactic being used here. We have an antitrust lawsuit filed by, I think, 14 players in district court against the owners. What do you make of the suit?
Well, first of all, the 14 players are seeking to represent a class of all NFL players. What I make of the suit is this. Under the antitrust laws, there's something called the statutory labor exemption. What that means is that when an entity is unionized, when it acts as the collective bargaining representative of various different individuals, it does not have the capacity to sue, or those individuals do not have the capacity to sue under antitrust law. So what did the players do here? Well, the players said, if we want to use the power of the antitrust laws, we're going to have to scrap our union, sue in our individual capacities, and then through that antitrust lawsuit process, hopefully negotiate a settlement that is to our liking. They're hoping that the threat of triple damages, which is what plaintiffs get in antitrust suits, could cause the owners to give up more than they would have in the collective bargaining process.
Was this their only option?
No, they certainly could have tried to reach a deal with the owners in the collective bargaining process. They may not have reached the same type of deal, and the deal may not have been as good for them, but they certainly could have tried that.
How do you expect the court to handle this suit?
Well, I think that the players have moved for a preliminary injunction barring the owners from locking them out. What does that mean? Well, a preliminary injunction is an order of a court saying to a party, before there's a trial, before there's any decree of illegality of a given practice, that defendant or group of defendants has to stop the practice. It's an extraordinary remedy. It's given in only limited circumstances, and it's only provided where the plaintiffs incur something called irreparable harm, where you're a business, you're going to go out of business without the relief that's being granted, where money damages cannot compensate you. Here, most of the players are millionaires. Even those who aren't millionaires are doing well. They have contracts for a stipulated amount of money. Clearly, their damages are calculable. So in my view, I can't see a court saying that the plaintiffs here, the players, have been irreparably harmed, and I don't see any injunction being granted. If that's the case, if the injunction motion is denied, I expect the players to recertify the union and for the parties to get back to the negotiating table.
Do you think it's actually going to get to that point? Do you think there might be some possibility for negotiation to happen outside of court and ultimately avoid all of this, or are we heading directly into court and that's going to be the end of it?
I think at this point that there's going to be a ruling on the injunction motion. I think the players said they were going to roll the dice, so they're going to go forward with it. There's still a possibility, of course, that the owners could come back with an offer that's more appealing to the players in the context of the class action settlement process, which, by the way, has its own problems. Class action settlements have to be approved by a court. Just yesterday, a court in New York, a federal court, just struck down a class action settlement that was reached between Google and publishers and a group of entities that represented authors. So just because there's a class action settlement doesn't mean that all the parties to that settlement, including all the individual players, are necessarily going to like it. But that could happen. They could negotiate an agreement before the injunction. I just don't expect that to happen.
All right, well, we'll have to see how it goes. Matt, I want to thank you for coming in today. This was a pleasure.
Sure. Thanks for having me.
That's Matt Cantor. He is an attorney at the law firm Constatine Cannon based here in New York City. If you'd like to learn more about the issues we just discussed, go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. I'm Lee Pacchia. Thanks for watching.